SJC-12233, Commonwealth v. Raymond White.
Ms. Leary, good morning.
Good morning. Catherine Leary, on behalf of the Commonwealth. Here, the single justice reinstated the defendant's direct appellate rights almost 45 years after his conviction. In doing so was error for 3 reasons. First, the single justice assumed without record support or without holding an evidentiary hearing that both appellate counsel, Attorney Hutton and Attorney Rankin, were ineffective. Second, the single justice ignored the prior single justice's ruling and order on this exact issue. And third, the single justice seemingly ignored that the defendant sat on his appellate rights numerous times for lengthy periods of time. This court has said that where defendants' direct appellate rights are frustrated, the appropriate and adequate remedy is a motion for a new trial. And here, that would be the appropriate remedy where the defendant could raise claims of errors as well as any ineffective assistance of counsel claims. And then should that motion be denied, he would be entitled to direct entry into this court as a first-degree homicide defendant.
And if we did take direct entry, would he enjoy the benefit of 33E?
If you took direct entry from the denial of a motion for new trial, yes. I think if you look at 33E, nothing in the statute prohibits plenary review based on only a direct appeal. And so the court would be able to look at the entire case, not just the errors raised, and give that unique type of review to a first-degree homicide defendant.
So why do you care?
Well, what's at issue here is whether the defendant is entitled to approximately half a century of developments in the case law. If he comes up on direct appeal, then seemingly he would be entitled to everything from 1974 through 2019 when it would come up on direct appeal, opposed to if it's a motion for new trial, even though the court is doing 33 review, it would be under the guise of looking under the law in the 1970s.
But if it were a public trial issue, and I know there's all sorts of permeations and waiver, I'm not asking about that. If it's 33 review, we have to look at it. If there's a confrontation clause issue, and I know there's all sorts of issues there too, but if it's there, we've got to look at it in the 33 review anyway.
I think, well, what the court would look at under 33E review, and I understand the court is saying that they can't blind themselves to any injustice that happened, but when the court does 33E review, the court reviews to see if there's any such manifest injustice that the conviction cannot stand, whereas if the court comes up on direct appeal, any errors raised, and depending on the developments of the case law, something could be reversible based on as if the court case had been tried yesterday, opposed to looking back at the case and it being tried in the 70s.
Is there, I think, perhaps an implication here regarding what this holding would do to the court's ability to enforce time standards or briefing schedules? What teeth would we have if we assume this was correct?
I'm not sure I quite understand your question, Your Honor.
It's a question for the other side. Never mind.
Right. Well, I think here, as this court knows, there's a problem with cases languishing on the docket and defendants possibly sitting on their rights and waiting for developments of case law, and that's precisely what the Commonwealth is concerned with, that here, if the defendant had perfected his appeal in a timely manner, he would have gotten the case law developments up until probably the mid-70s. I can't say what date the appeal would have actually been perfected, but here he would be getting a windfall if he gets direct appeal by the developments and changes in the case law, opposed to here, if we follow the procedural route laid out in Commonwealth v. Cowie, that he would be entitled to review claimed errors, an effective assistance of counsel claim, develop that record, because on this record, it's not clear that was ineffective assistance of counsel. I would say it, in fact, supports the defendant's sound his rights and didn't pursue his appeal. And so the defendant receives everything he's entitled to based on the Commonwealth's position and not the windfall based on getting direct appeal. And here, as the court has noted numerous times, the procedural time limits are in place for a reason, based on the Commonwealth's interest in the finality of judgments, victims' rights, that these cases be adjudged final. And if this case is overturned, the Commonwealth cannot retry this case.
Can you help me with that, please? Because I'm having a little bit of trouble seeing how, when we ultimately look at the case, either immediately or after a motion for new trial, how the analysis is different. There may be all sorts of waived issues. There may be all sorts of concerns, because, including there was an escape in this time frame as well, correct?
Correct. Well, I think.
So then my question is, I still don't understand, it might be the same question
Okay.
the chief asked, which is, when we're writing this decision, what's different if we take it directly or if it's a review of a motion for new trial? What's different in the analysis?
Well, what's different in the analysis is, first, after a motion for new trial and after an evidentiary hearing, cases such as in Petabella and Robideau, the court would be able to determine first if the defendant had quote-unquote waived direct appeal based on strategic input and decision made with defense counsel, and then, or whether or not the defendant just kind of sat in his rights and didn't do anything. When it's based on a strategic decision and on the counsel advice of defense counsel, then perhaps the case would come up direct entry, but it would be, the court would look at it under substantial risk. I don't necessarily think 33E review, plenary review of the whole case necessarily has to be done with substantial likelihood, opposed to after an evidentiary hearing, if the Superior Court judge determines that it was just procedural waiver, and then the case would come up on 33E review and look at the whole case, but look at it under substantial likelihood, which is what the court did in Wilson and Brito.
So
answers
are
your
you saying then that there are some things, some issues of law that a defendant could have, that we would consider under 33E, regardless of how the case came up, or whether anything was retroactive, or whether something had been due the defendant because of when the appeal had been filed and docketed, that some of those issues wouldn't necessarily result in a reversal because of the nature of the issue, but if they were properly considered to be properly preserved because there was still a right to the issue because it was pending on appeal, the case is still pending on appeal until it's entered, there'd be a benefit to the defendant that he wouldn't be entitled to. Is that what you're saying?
I believe so. It's a
I may have not have phrased it well, but
right, because this court has repeatedly said, while a case is pending on appeal, the defendant is entitled to the benefits of the case law. So there's some instances where there's new law that's come down where perhaps under 33E review, it would not be such a manifest injustice that would require reduction of the verdict or a new trial. However, if applied, it would be and preserved, it would be reversible error. I understand the court. It's hard to...
Give us an example of that. I am confused once you've conceded that there's 33E. Give an example of where it would make a difference, any kind of issue.
I guess I'm not entirely sure how this would play out, but perhaps the reasonable doubt instruction, I believe in Commonwealth v. Bonds, that is 424 Mass 698. There, the court noted the importance of whether or not to apply the developments in the case law, because if the case had been gone up on appeal before, the reasonable doubt instruction there would have been upheld, and even under 33 review, and now when we were applying the new developments in the case law, it was reversible error. I understand the court's struggle with this, that, how does the court blind itself under 33 review to certain, developments in the case law, but looking at it in looking at a case that was tried in the 1970s under the law in the 1970s, I think you can still review the case, looking at that law, and then still consider, the general possible social science changes or other stuff. You can't blind yourself to that, but I think the real effect is whether or not a raised error and preserved error would actually be reversible.
Here we have this peculiar, going back to what the law was, in 72 there was a death penalty. And here he was sentenced to death. And the judge stated pending appeal, and therefore it made perfect sense for a defense counsel, who may not have had a great appeal, to say, well, it stayed pending appeal. The surest way to keep him alive is to... keep the appeal, is not appeal, or is to have the appeal outstanding, and then I guess when he ended it and said, okay, I'm not going to impose death, I'm going to impose a life sentence, I'm not sure if that was after this court declared the death penalty unconstitutional, I forget the dates. But that's, I mean, so there was a perfectly sound reason for the attorneys at the time to not present an appeal, because if they had done so and they had lost, their client would have been executed.
Right, which is the fact pattern in Petabella and Robideau, I'm sorry, mispronouncing the case name. However, here, well, on this record, we can't speculate what happened and why it happened without cross-examining the defendant, getting affidavits from Attorney Hutton or Attorney Rankin, which both of those defense attorneys are still listed as active on the BBO. But here, I think the writing was on the wall that the death sentence was going to be ruled unconstitutional or had been ruled unconstitutional at that point. And so here, it's clear that if you look at the record in the docket, Attorney Hutton was present when the defendant's death sentence was vacated and the life sentence was reimposed, and that they were working together. And so we don't know what happened between I believe it was 1977 or 1976 when that happened.
But what possibly, if you're not faced with the death penalty, what possible good reason is there to not appeal a life without parole sentence? There's nothing you can lose.
Well, Your Honor, respectfully, that's what an evidentiary hearing would be helpful to kind of ferret out from this record. We don't know. And I would point to Wilson, Brito, Petabella. I guess Petabella and Robideau are not great examples, but Wilson and Brito, they didn't do a direct appeal. They chose other remedies. I think in Wilson, it was a Rule 30A motion. In Brito, it was a motion for new trial. So I can't surmise what goes on in a defendant's head or between him and his appellate counsel or defense counsel, and that's precisely why an evidentiary hearing should be held in this. Either this court would be able to do so, or it could be remanded to the Superior Court for such. But on this record, even if the court were to find 33 doesn't apply or is inappropriate, whether that is prejudicial to the defendant in not getting 33 review on a first-degree homicide case is the second prong of Safarian, and we haven't gotten to the first prong yet.
So you're making an argument that as a practical matter, requiring this to start with a motion for a new trial makes more sense? Is that what you're saying? That we will we'll resolve these uncertainties?
Yes, and I would point the court to the footnote in Commonwealth v. Cowie where they discussed Everett v. Lucy, which is the Supreme Court case, and saying it was undisputed on that record there, but a motion for new trial is the best place to ferret out these issues. On this record, it just is not clear. And in Commonwealth v. Franks, where it was undisputed in that case, but Commonwealth conceded that defense attorney was ineffective, then perhaps reinstating appellate rights or letting the appellate counsel decide whether to file a motion for new trial or direct appeal is appropriate, but that's not the procedural posture of this case.
So why doesn't it inure to the detriment of the defendant not to have a motion for new trial in Superior Court? Because we're not going to be able to analyze whether or not there was a strategic reason for something, or whether or not the second prong of Safarian was satisfied, or whether or not the conduct was below that of a reasonably competent attorney. So if you don't have the motion for new trial first, doesn't that inure to the detriment of the defendant?
I would think it would be more favorable to the defendant to have a motion for new trial so he could ferret out these issues and build a record. And if it's determined that counsel wasn't effective, then he would most likely be granted a new trial.
That's what I'm asking.
Yes. I agree.
A new trial or an appeal? I mean, are you referring to ineffective assistance of counsel with regard to filing an appeal, or ineffective assistance of counsel at trial?
I would say, well, perhaps at trial as well, but I would think the main issue here would be appellate counsel, whether or not Attorney Hutton was ineffective, and then later Attorney Rankin for not appealing the single justice's order, which decided this very issue.
And let's assume for whatever reason that happens and you go before a Superior Court judge and the Superior Court judge says they were not ineffective and I deny the motion for new trial. Do you go before the gatekeeper or do you come directly to the the full court?
I think you would come directly before the full court because there's been no appellate decision and no rescript. And the footnote in Commonwealth v. Bonds, footnote 1, discusses that no gatekeeper requirement where there's been no rescript and no appellate decision. So,
And then when it comes to the full court can consider not only the motion judge's decision as to whether counsel was ineffective in failing to file an appeal, but also the entirety of the court record and any matters with regard to the trial itself?
correct, but looking under the case law at the time.
Okay, thank you.
Thank you.
Mr. Goldman, good morning.
Morning, Your Honor. May it please the court, Richard Goldman from Mr. White. So it might be helpful just to take a step back for a moment and before I hopefully get to some questions. In terms of the question of Mr. White's, the intent to appeal, which again, or what steps he took. So the Commonwealth asserts or suggests that there was a reason for not appealing, and Your Honor has mentioned. But Mr. White, convicted in 1972, within a week, a timely notice of appeal was filed. Within a week of that his conviction, Mr. White wrote a letter to the Superior Court Clerk's office saying he wished to appeal. I intend to assert my appellate rights. This is in the record. Justice Botsford found this, recounted this. Mr. White continued to try to assert his appellate rights. Writing this letter in 1972, he writes a letter to his lawyer, to Charles Lewis, who's representing him at the time. He says that he wants his rights on appeal protected to the fullest extent. And so he's making efforts to assert his rights throughout the time period, including up through 1980 when he files a pro se motion for new trial. His death sentence was as a result of Furman versus Georgia and Stewart, so 1976.
And in 1976, his co-defendant decision comes out, which is very damning on the facts for both of them. They're caught with the money. They're identified. Mr. White, your client, worked at the security service that he robbed. He's seen by a manager and identified by the manager. This is an uphill battle, this case, right?
Correct. But
guns, they find the guns from the shooting at the, right, so it's a tough case.
But right? Mr. White did testify, and he asserted his innocence at trial. So, and he, throughout these years, he's tried to obtain his direct review. And so in one of the concerns from the court is the question Justice Seifer asked, I believe, about how does this affect other cases, or what's the impact beyond this case? I think none, because again, we have a defendant convicted of first-degree murder in 1972, before the rules of appellate procedure are in place. Justice Botsford found that 27833E controlled, and I think she was correct in that, and that under 27833E, there's no time constraint to the direct appeal. He did file, again, his attorney did file a notice of appeal, as Justice Botsford noted in her.
Wasn't there a statute that referred to a 6-month limit on manslaughter and murder appeals?
It's in my brief. There was 27833E through G. However, the Commonwealth versus Nassar, which I've cited in my brief, held that while the statute provided 6 months for a defendant to file the notice of assignment of errors, that could be enlarged as long as necessary, basically. So this court held in Commonwealth versus Nassar that 6-month time period was not a bar.
Okay. But you're saying that this would have this would not provide any incentive for anybody to just ignore completely any briefing deadlines? There's just no, I mean, what would we be able to do possibly to encourage anybody to file their brief on time?
Well, I don't think it's this case, but for example, 14B, under 14B, a single justice would have discretion. If a defendant files a timely notice of appeal, I think under 14B, as Justice Botsford found, although she didn't reach, I think she had to reach, she didn't rely on 14B, she didn't address it, but I think a single justice would have discretion to enlarge, to reinstate an appeal, but again, I don't think that's this case.
So
This is a
so
first-degree-
you're saying that we would dismiss it for failure to file a brief, and then, on a first-degree murder case, and then or a single justice would have to reinstate it?
I'm not sure I follow. In this,
I guess I don't
in this
understand
case,
what you're saying.
because in this case, there was Mr. White filed a timely notice of appeal.
Right,
The appeal was dismissed because his lawyers failed to perfect the appeal. And so 1974, the appeal was dismissed. When it was reinstated for both Mr. White and Mr. Hall, this court actually admonished, for better term, the Superior Court and said, how did this happen? When we should take steps to make sure this doesn't happen again. But Mr. White gets reinstated, but then, so in 1974, single justice of this court reinstates his appeal, his direct appeal. So, and that's so the appeal, in terms of Mr. White, again, I think this is a very limited case for the court.
But it gets more complicated because Justice Nolan, it does get resurrected, very capable defense counsel representing him, and then they don't appeal Justice Nolan's decision. So,
Right, but
so really, isn't this going to be precedent for even our single justice decisions can get revisited 40 years later?
well, there
Because
was.
I don't see the difference between what Justice Nolan did and what Justice Botsford did. What would be the purpose of the motion that was before Justice Nolan if it wasn't to do exactly what Justice Botsford did, which is to get the case back on track?
Well, it may be to get the case back on track, but I think there's a significant difference between a motion to which was in 1992, a motion to transfer the record or to transmit the record from the Superior Court to this court, as opposed to 2014, which is a motion to reinstate the appeal.
But isn't,
For example,
if you deny the one, if you don't even allow them to transmit the record, aren't you absolutely per se going to deny the bigger issue? Isn't Justice Nolan's decision effectively the same decision?
Well, again, taking a step back, I think not necessarily, and if you look at the way that Justice Nolan and Justice Botsford treated, as single justices treated those those petitions before there were motions, Justice Nolan it was essentially not totally a summary denial, but essentially for saying there was argument,
But there's no
consideration
appeal.
denied. But
There's
Justice
no
Botsford-
appeal by Attorney Rankin. Rankin
Yep.
knows how to appeal. So he doesn't appeal that case. And now we're assuming that Justice Nolan's decision was, of no import. We could have clarified that in 1992, couldn't we?
Again, but there was no appeal. There could have been an appeal. Again, it's Mr. White filed an affidavit with his pro se pleading in 2014, saying that he didn't realize that he had.
Do we have
the ability-
anything from Mr. Rankin?
No,
So we don't have anything. Have you consulted with Mr. Rankin?
I have. It's not in the record.
Okay, I don't wonder if it's not in the record.
But again, Mr. White, throughout the years, he is, and there may be gaps, but he is
they're kind
consistent.
of big gaps. I
There are
mean,
there are gaps, but he comes back and says, okay, I never had an appeal. It's a defendant convicted of first-degree murder.
I
And
understand.
in terms of the choice of law and the 33E question, I think I've cited in my brief Commonwealth versus Beauchamp and Frank. I think Beauchamp is really the controlling case in this. What happened in Beauchamp, a very similar circumstance, is that a defendant was convicted of first-degree murder. There was an escape, so no appeal was brought forth. So the defendant in Beauchamp was convicted in 1973. I'm sorry, second-degree murder. But at that point, second-degree murder was covered by 27833E. So he's convicted in 1973 of second-degree murder. He escapes in 1974. In 1987, he's returned to custody in Massachusetts. In 1993, files a single justice petition seeking review. And what this court did in
Seeking
Beauchamp.
review of what?
He wants to file a late application for notice of appeal, to file an appeal. And what I would assert would be what this court did in Beauchamp is what it should do in this case, in Mr. White's case. Because what the court did in Beauchamp is it allowed full court review, 278-33E, direct review, and then treated as, I think Your Honor suggested, or maybe suggested, each issue that came up then that the defendant raised was analyzed, I think maybe it was you, Justice Lowy, analyzed under its own merits. And so, and in terms of the standard of review. And so what happened in Beauchamp was the defendant made two basic claims. This court found that there was self-defense that was reasonably raised, and the question of the instruction, whether the burden of proof had been shifted on self-defense. And so the
that
case
was a
tried
33E conclusion?
well, yes, but what happened was, the case was 2 years after, Beauchamp was tried 2 years before Mulaney versus Wilbur. And then which is 1976, 1975. In 1976, this court, Commonwealth versus Rodriguez, applied Mulaney in Massachusetts. Then in 1978, it applied Rodriguez in Commonwealth versus Stokes retroactively. So this court in Beauchamp looked and said, we've already done this on collateral review in other cases. We can take a look at it, and that's standard. And same thing they used, there was a Doyle issue and pre-defendant's silence. But so the same thing would have to happen in this case, where each issue, and what happened was so that the court allowed Beauchamp's appeal, and also in Commonwealth versus Frank, the defendant and defense counsel to determine how best to proceed. So the court didn't dictate you must file a Rule 30 motion, or you must come to us on direct appeal. You decide as the defendant, with counsel, how best to proceed, and review the claims appropriately. That's how I think the claims would need to be presented. The standard of review might differ depending on the claim and whether this court had applied it, like in Beauchamp, to other cases on similar review or not. It gets complicated perhaps, but not too complicated.
Can you explain your understanding? If we rule the other way and said that you had to file a motion for a new trial, how would that change the legal universe in your view?
Well, I think the Commonwealth relies on Commonwealth versus Brito in their brief. And this court in Brito, I think if it's a direct appeal, and this is what Justice Botsford found, and I think absent a clear error of law or abuse of discretion, this court he should affirm Justice Botsford's order. But but if it's not, so the Commonwealth is Brito. The Commonwealth says there was 33E review, but this court applied 33E review on discretion. It noted it didn't have to. In Brito, the case was dismissed because there was a non-conforming brief, I think.
So your view is that if it's a direct appeal, 33E is mandatory, and if it's not, it's discretionary?
Yes. Mm-hmm. And the important rights to the defendant involved in a full and complete review of his convictions, given that 278-33E is the only statute that applies to first-degree murder cases, which again is why I think it's a limited case and not beyond, given the age of his appeal and predating the rules.
How does that change any current cases, though? I mean, you say it would be different because the rules have changed, but I don't quite understand how the rules of appellate procedure now would make any difference.
Well, again, I would think that a first-degree murder conviction wouldn't fall through the cracks for 45 years with no appeal.
Probably
and again,
not.
I'm saying it's just the first 278-33E review. I don't think you get to Rule 14 in this case, and Justice Botsford didn't. So I don't think there's any kind of effect beyond to other cases I think for a first-degree murder case would be dealt with.
But you don't think as a defense attorney, if you had a reason, but if the case, they're co-defendants and a strong opinion came out from the court and it just looked awful for the other co-defendant on appeal, there's no incentive to just wait and maybe things will change eventually in 20 years and there'll be a better shot.
Well, for one thing, I think, again, as Justice Botsford noted in her decision, Mr. White didn't do that. He threw out, and admittedly there were gaps, including an escape. But again, the escape just takes him away for the period of time he's out of the Commonwealth. But once he's back under the case law.
I mean, it's minimal within the 45 years or 42 years. It's not
Right.
that big of a proportion. I get
Correct.
that, yeah.
Correct, but, right.
Although he escaped for what, almost a decade?
I believe it was from 1980, and he's returned in 1989, or.
Good
so,
escape.
But he was
You're
in.
saying even if there was a direct review, say there was, you mentioned a Doyle issue, a self-incrimination issue, or say there was a confrontation clause issue, we would have to analyze whether or not, considering that the conviction was 40-something years ago, whether or not that's actually going to be analyzed in a substantial likelihood of a miscarriage of justice, or whether there might be a waiver or a different standard, and we just have to go through each issue and analyze that. It wouldn't just as a reflex automatically be 33E for each issue.
Well, correct, well, yes, I mean.
I'm asking, I'm not asking you for the answer, I'm asking you if that's what you
Right,
said. Your
I guess what I'm
position
saying,
is.
under Griffith versus Kentucky, so the presumption, or whatever, for lack of a better word, is that new case law would apply, but changes in law. But yes, I think the reality would be still under the umbrella of 33E review, but for each case. So I think 33E review is present, but for each claim, it would need to be analyzed under the specific changes in the law.
Right, because you'd
like
be
in Beauchamp.
recognizing that 40 years ago, there wouldn't have been Crawford versus Washington, and so losing that doesn't necessarily create a substantial likelihood of a miscarriage of justice.
Yeah, I think
Is
it's
that
like.
what you're saying?
I'm saying what the court did in Beauchamp, which, so if it finds that and in Beauchamp, there was a reversal. But the court had to find that the error was of a magnitude and that warranted reversal, and that it had also applied that law, or that change in the law, to other cases on collateral review. So, but it's still under the umbrella of 33E review. If that.
Thank you.
Thank you.